core of the group. They remain on the core. But it's not clear whether they're always the same people. But certainly there were dozens, maybe 100 people tops remained on the copy at night, and then during the day you could see the others coming back together on the copy. So unremarkably, the whole basis of the 10 Colonel Scott's plan was that it had to be executed early in the morning, at about 6 in the morning, when there were only dozens or hundreds of people there as opposed to thousands. Then the police could safely encircle this person's arm, set up their corridors, and then search and, if necessary, arrest armed people coming to the Kopi. But the whole point would be the Kopi was the central focus of the strike. It was where the rituals were carried out that we know about, the Muti. That was the core, that's where they gathered. So if you took possession of the Kopi, they wouldn't have a gathering place and hence they would be dispersed. You wouldn't have to go in to disperse. But that can only work in the morning. And the crucial thing is not whether there was a tactical option or cards from the outset. It is why was it so important to do it at 3 o'clock in the afternoon when the situation was hopelessly different. There were 3,000 people there. It was the worst possible time to do it. That is the point, which is missed by the National Commissioner's submissions, and all her answers don't deal with that central problem with the entire operation. That is the problem with the operation. And there are only two possibilities. She knew that it had to be carried out early in the morning and that this was a disaster waiting to happen. And anyone with a modicum of understanding, let alone the National Commissioner, should and would have known that this could never safely be carried out at 3 o'clock in the afternoon. And we know, I've read to you, her own statement says that she was called by Lieutenant General Bomber on the 16th of August. She was telephoned, and you find this at page 15, and I just want to reiterate this. Page 15 of our heads, of our submissions, at paragraph 23, this is her own statement to the following commission. She says, on the afternoon of August 16, 2012, I received a call from Lieutenant General Bomber, who informed me of a decision to implement the dispersal operation of the plan. Now, what is glaringly obvious, members of the board, which has never been answered and which lies at the heart of this first leg of this board inquiry, but also the second, because remember the second leg is, should the catastrophic and tragic consequences have been foreseen? And these are integrally connected. Our submission, our central submission, is that anyone with a modicum of understanding of the situation, let alone a police commission, the National Commission, who's tasked with being in charge of the police, should have known, because she knew she'd been briefed, and we have the references in our heads to that as well. She was continually briefed. Because remember, she went to Marikana for the first time on the evening of the 13th, after the 2 police officers had been brutally killed. She was flown there by helicopter, she got a briefing, she went to the London mine, she spoke to the mine managers, she was briefed, and thereafter she returned to Pretoria, but was regularly briefed. That's what her own statement says. So she was kept up to date about what was happening. And then on the 15th, we know that she's at the meeting. So, on the 15th already, when the proposal is endorsed, she should have known, right. Now I'm being told tomorrow is the day that this is going to happen. So now, she doesn't hear that it's happening at 6 o'clock in the morning. She then gets a call in the afternoon to say, now we're going in. Now, what would a prudent, reasonable, responsible National Commissioner of Police do? We submit, the answer is obvious. She should have said, what are you talking about? Why are you going to do this afternoon? There are thousands of people there. You can't do it safely. Or she should have asked questions. She should have said, what steps have been taken to make sure that people don't get killed or injured? She did not do that. And there are only 2 possibilities that flow from that submission. And that is, she was not aware of the importance of the 6 o'clock window period to undertake the operation, which would make her grossly negligent and incompetent, and thus unfit for office, to not know the most important detail of the most important police operation in this country since democracy, or she did know that, and closed her mind to the fact that the window for this operation was long past, and it could not safely be done in the afternoon, in which event she was grossly negligent and incompetent.
If that is true, then it was intentional.
Well, Judge, we make the submission in our heads that if she had actual knowledge, because the submission is made by our colleagues in answer to the second leg, they say that there's no evidence that she knew of the catastrophic consequences that would ensue. And we say that misunderstands the second leg. The second leg doesn't impute actual knowledge. It says whether she should have known. And that's as far as we go. We don't need to go further. But in light of what you just put to me, Judge Classen, if the finding is that she did know, then it's quite possible that she is guilty in a fiduciary capacity, either of murder or culpable homicide, because then she'd have actual knowledge. But we don't need to go there. We don't say she had actual knowledge. But it's one of those options. She either had actual knowledge or she didn't. On either count, it's inexcusable and renders her unfit for office. Then, Judge, I'm going to, here's the board. We then in Para 60 deal with the Planning Commission finding. I'm not going to refer to that. Para 61, we make the point that endorse means to declare one's public approval or support. The authority for that is the Oxford Dictionary of English. And we say clearly those at the meeting, including the National Commission, are now paragraph 61 on page 62, approved of and made common cause of the Provincial Commission's decision. There's no other explanation tenable. She strenuously denies that the existence of the extraordinary meeting and the decision taken at that meeting was only brought to the attention of the evidence leaders in the Parliament Commission by a third party months after she'd already given evidence. Then we give you a reference, Judge, to her evidence about the point you asked us for, and we will look for the answer to the precise timeline.
Yeah.
I don't have that to hand at the moment. So she refers, we say, to her statement. She also admits that she was extensively cross-examined by Advocate Bezos regarding the extraordinary meeting. We say her representations in this regard are frankly disingenuous and are only consistent with an attempt on her part to mislead the President as well. In this regard, she was aware that the criticism of the evidence leaders in the Commission of the failure to mention the extraordinary session was because of the decision, and then we throw out now, say, or endorsement of the decision to cater for her argument. Taken thereafter, the following day was to be the decisive day that the strikers were forcibly disarmed if necessary. Accordingly, we say it must have been apparent that that wasn't a frank response. And we give you the reference in paragraph 64.3 to the cross-examination of Advocate Bezos, which, although robust, as is his wont, does not deal with the extraordinary meeting because he wasn't aware of the extraordinary meeting.
He was not.
He wasn't. In his cross-examination is the first round, Judge. He wasn't aware, and you can have a look at the reference.
That cross-examination occurred when she testified for the first time.
On basis A, that's correct. Then we go to her representations in paragraph 65. I'll take you there in a little while. And we say in paragraph 66, she then characterises the Commission ignoring the SABC submission of this aspect as being malicious in its content and scope. And we address that later with relevance to the testimony and whether the testimony renders unfit to the office that she has. And we say what the reliance on the SABC submission ignores is in para 305, referred to in para 65, is the fact that in a different part of the heads of argument, the same heads of argument, they say the following. Both the National Commissioner and the Provincial Commissioner did not disclose in their statements that there was an extraordinary meeting held with Deputy Commissioners and Provincial Commissioners on 15 August. The evidence of both the National Commissioner and the Provincial Commissioner, is that this was an oversight. It was also the evidence that in considering Exhibit L, which did not make reference to the mid-round meeting, it was again an oversight not to realise that omission. Now, the first point we make about that explanation, members of the board, is that if it was an omission, then what is said in para 305 can't be correct. Because para 305 gives a deliberate reason for not dealing with the extraordinary meeting in Exhibit R. It says we didn't deal with it because Exhibit R only dealt with the facts of the operation, as we say in para 65, and
you say in that instance, if that was the purpose of Exhibit L, it was not an oversight.
It's not an oversight.
It's deliberate.
So,
intentionally deliberate.
Yes, it's intentionally left out because it's not a fact of the operation. Now, if you unpack that, to use a horrible phrase, Judge, if you unpack that, the first point is not only is it a fact about the operation, it's the most important fact. It's the most important fact that it was an extraordinary meeting because the rest of the operation flows from the meeting. So how can you possibly say it's left out deliberately because it's not a fact? It is a fact. But if you give that answer, you can't in the next breath say, well, it was also an oversight. That's logical in our submission. So the heads of...
If the oversight explanation is correct, that would mean that in saying it's an oversight, it constitutes an admission that it was part of the operation. It should have been included, but unfortunately we forgot to include it.
And we didn't forget to include it only in Exhibit L, which was conceived at the Rhodes Conference after 10 days of rigorous introspection by the SABC. But it was also overlooked in both the statements of the National Commissioner and the Provincial Commissioner. So that's three oversights, three separate oversights. And we say that you just need to consider the explanation given to realise that this is not the evidence of a truthful witness. But I'll just take a moment, Judge. I think it's with regard to your question.
Yes, thank you.
Judge, it's on, it may not be a complete answer. It may not be a complete answer to your question, but it's the evidence of General Phiyega when she's recalled. And you found it at, what day is it? It's 288, members of the board, and it's on page 37,429.
I've got the record in front of me, so...
Did you have day
37?
37429
429.
on day 288.
429.
So this is when she's recalled.
All right.
At line 20, Judge, on that page, the chairperson says, let's move on to another matter. Police expert Mr. Riah gave evidence last week, and I want to ask you this, a number of questions about what the setting is relevant. Was the fact that this meeting took place and this decision was made originally disclosed to Mr. Riah as part of his briefing? I do not recall, Chair, but I don't believe that it was necessary even to go into those details because he was looking at everything and he would have found out about it because was never a hidden thing, in our opinion. Where would he have found it? In his engagement with the organisation. But where? In his engagement with those that would participate. He would have engaged with General Mbombo, he would have engaged with General Annandale, he would have engaged with any other person, and those issues would be part and parcel of the discussion. Now see, what I was telling you, he told us that it was, to use his word, divulged to him by a third party over a cup of coffee, as he put it. And he then subsequently raised it with you and Generals Annandale and Pembe. Does that surprise you that it was only divulged to him by a third party over a cup of coffee? And he then raised it after it had been so divulged. Does that surprise you? Wouldn't you have expected that to have been part of the basic instructions that he received? It would surprise me, Chairperson, because the divulging suggests that there is conspiracy, there's a secret, and I'm on record, and I'm putting it again on record, there was never a secrecy around that matter. So we know, Judge, that it came to light at the Foreign Commission when Mr. De Wever gave evidence in the previous week, today, 288. So we can try to track his evidence and give those references to you. I don't know whether that answers your question, Judge.
Well, it answers it to the extent that we now know the person who divulged for the first time the existence of such an extraordinary meeting was the policeman Deroga.
Not policeman, he's a police expert witness.
Expert witness, yeah.
He was called.
He spoke about it when he testified and told the Foreign Commission that he was told over a cup of coffee by somebody else.
Yes.
In confidence.
No, I can't recall that it was in confidence. I don't think so. It wasn't in confidence, Judge. And that's how this comes to the attention of the Foreign Commission. And then it seems the following week she's recalled as a matter of some urgency.
Yeah, thank you.
Thank you, Judge. And then I was reading to you from the SABC heads, and I just want to read to you paragraph 318 on page 65 of those heads. They go on to say, mitigation over, there was no attempt on the part of SABC to conceal the fact that the operation was authorised by the Provincial Commissioner as she was entitled to in terms of section 37 of the Act, and that all the provinces were requested to assist with their resources to help the North West Province to contain the escalating unrest. The non-disclosure, therefore, could not have a sinister intent behind it, and the explanation that this was an oversight must be accepted as true. Now, there's a whole series of difficulties with that proposition, as I've already put to you, but most obviously it was concealed because it was never disclosed. And that's the definition of concealment. We say that, apropos the argument by her or submission that it was an oversight to not refer to it in the various statements made by the top two police commanders and officers, namely herself and Lieutenant General Mbombo, we say this is an extraordinary, in para 70 of our submissions, an extraordinary submission to have been made and to have been endorsed by the National Commissioner. And it's made in the heads of argument, obviously. Given the manifest purpose of the Foreign Commission, i.e. to get to the bottom of what had happened at Marikana, and given the fact that it may safely be assumed that the National Commissioner's statement was prepared by lawyers after having consulted with her and taken instructions from her, to assert that the meeting was overlooked, not only in her case, but also in that of the Provincial Commission, is preposterous. And we use that word advisedly. It's simply not believable that any lawyer told about this extraordinary meeting would have looked it up. And we say in para 71, at the absolute minimum, and if she wished to persist with this assertion, she should have been prepared to take the witness stand and do so under oath, because we would certainly have had questions for her. By not testifying, she has denied both the evidence leaders and this board of inquiry the opportunity to test what it is respectfully submitted is plainly a fabrication. In paragraph 74, we deal, I'm not going to read it to you, but that paragraph deals with her knowledge of the content of Exhibit L. She was expressly asked by the chairperson whether she approved the contents of Exhibit L. Her answer, we say, was at best for her evasive, but culminated in her agreeing that she had not disapproved of its contents. And if you merely look at Exhibit L, and we're in the process, members of the board, of having colour copies made for you of that document, but if you just look at the document, now that we know it was actually, and you will see from it, it is a slideshow, so it would have been pictorially presented on a screen. It's not possible to overlook the fact that there's no mention of this meeting on the 15th of August. It's like an elephant in the room. In paragraph 79, members of the board, we say that the fact that the police leadership in general, including Lieutenant General Mbombo, and the National Commissioner went to such lengths to conceal the fact that there had been this extraordinary meeting and that a decision had been taken thereat that was to have devastating consequences the following day, as well as the convoluted and frankly unbelievable explanation was given for not disclosing the meeting and the decision taken thereat, is indicative in our submission only of a desire to hide something. It can't be an honest series of mistakes of this magnitude.
Can I ask a question?
Yes, Judge.
Because I wasn't at the Parliament Commission. I wouldn't know.
I wasn't either, Judge, but I'll try to answer it.
Well, if I remember correctly, there was quite a debate about who gave the order to begin the shooting on the 16th.
The shooting?
The shooting and the killing on the 16th.
Yes. Well,
is the answer to that question that order actually emanated from this extraordinary meeting, or is the answer that it emanated from somewhere else?
Judge, my understanding and my submission would be that we don't seek to make it a case that the police decided in this meeting on the 15th of August, which we now know about, that they intended to kill people the next day. That's not our case. We haven't made it a case. Okay. And we don't submit that. What we submit is that by authorising an operation of this magnitude, and remember there were hundreds of police at Marikana, including, as we know, heavily armed, specialised units, like the NIU, the TRT, and the something else, another unit. And the PFP, but there's another one that I'm forgetting. And
SDF.
I think it's, yes. And she knew, or should have known, that by authorising this operation, all those units would be brought into play. And by allowing that operation to be dictated, as we submit in another part of our heads, by extraneous considerations, which we say she was motivated by, by permitting that operation to happen the next day, regardless of what the position on the ground was, which we also know was the case, she should have foreseen that the likelihood of bloodshed and a disaster was very high. But I'm not suggesting, because my understanding of the so-called scene one, and it's well documented, it's the scenes we've all seen on TV, that show a line of heavily armed police. They're armed with R1 rifles, and they're the ones with the berets that Captain Claudia spoke of. They're a special police unit, the TRT, the Tactical Response Team. They are the equivalent of the SWAT teams that we see on TV in the United States. They're the people you go to when things are really bad. They protect the other police. It's that bad. So they were in a line of about 70. And the first group of strikers who died, you can see them, they come in a group, precise number, 20, 30 maybe, and they are jogging along and they're carrying weapons. And they come and they basically charge toward the police line. And I don't think there's any order from, I've seen that video a number of times, I don't think there's no order that is discernible that says shoot. what there is stop shooting after the initial volley. But that happens, Judge, it appears to be the police defending themselves when they are charged with a group. So to answer your question, no, I don't believe there was an order to shoot. We certainly don't say the order emanated from the meeting, but what we do say is that by triggering this operation, the endorsement triggers the operation provided the arms are not loaded at 9 o'clock the next morning. That is then an unstoppable train that is going. And that puts the police are not to blame. That line of TRT officers, we don't impute any blame to. The other parties may, but we don't impute any blame on those police officers. And even the following commission says that they were probably acting in self-defense, justified self-defense. But the National Commission is responsible for putting them in the position at 3 o'clock in the afternoon, which they shouldn't have been placed in. They should never have been faced with those strikers at that time of the day. So that's the blame that we impute to her.
And then, how long after that did scene 2?
Scene 2 happens about half an hour later, Judge.
Half an hour later.
And there is no footage that we are aware of, video footage of scene 2. We are just aware of the very disturbing photographs afterwards, and they're going to be alluded to by one of my learned friends on the left about the tampering of the scene.
But that's in the copy. That's
on the copy.
That's where the police went into the copy.
That's where the police.
And that was regarded as scene 2, that was tampering that occurred there.
And that is separately, both geographically and time-wise, to scene 1.
Yeah.
Scene 1 is the charge.
Yeah. Thank you.
Thank you, Judge. Then in paragraph 79.1, we make the point that the National Commission was pertinently asked by the chairperson when she returned whether any dissatisfaction was expressed at the extraordinary meeting at the fact that armed protesters were appearing on television, brandishing dangerous weapons while not being arrested. And she denies that there was any such concern raised at the extraordinary meeting, and that we have in paragraph 79.1. However, Lieutenant General Elias Mawela, the Divisional Commissioner for Operational Response Services, was at that meeting. He's a high-ranking police officer who is in fact responsible, Judge, for the deployment of these special units throughout the country, the TRT, etc. He's the overall commander who deploys them. And he was at the meeting, and his statement is in fact attached as Annexure 4 to the Commission's response to the President. And he says in his statement that she attaches to a submission or to her representations that the meeting encouraged her to continue, this is Lieutenant General Bombo, to continue.
Her is a reference to Bombo, not to
the National Commission, to Bombo, to continue with their intervention and maintain public order. She was also advised to inform the public about all the interventions and initiatives she is currently employing to stop the violence and dispel the growing perception that the police are helpless while people are being killed. Now this is, one of our own officers says that this was told at the meeting to the Provincial Commission. You're not doing your job, in other words. People are being killed. Everyone sees this on TV and you're doing nothing about it. You must dispel that notion. So pressure is then put, we submit. That is a logical, fair inference to be drawn from that piece of evidence, another piece of mosaic, that now pressure is being put by the top police command on the Provincial Commissioner. This can't go on. And again, that ties in very neatly with the D-Day scenario. Tomorrow, this has to end. And had the police, with the benefit of hindsight, we know, this could have been held off, this operation, till the Friday morning. It could have been done at 6 o'clock on Friday morning. Because the excuse given for not doing it at 6 on the Thursday is they were waiting for Mr. Mtunjwa, who was going to come back to them at 9 o'clock. And there's some criticism of General Bongo, who didn't come back. She says in the briefing at 1 o'clock, she says, Mtunjwa didn't come back to me. That's why we couldn't do the operation at 6. But now we can do the operation. How does that make any sense, Judge? What should have happened is it should have stood down to 6 o'clock on Friday morning. Then this would not have happened, in all likelihood, or at least not on the scale. And that is the essential dilemma which faces the entire police operation. It was done at the wrong time because of reasons extraneous to sound police operational reasons. Now remember, Judge, I read to you yesterday the long passage from Major General Annandale's evidence. If that evidence was true, then that would be a sound police operational reason to do the operation, and they did. If they genuinely feared that this group would go and kill people. But that evidence is not true. We now know it's not true. That is not the reason. And the police council says, forget about that evidence. That's not correct. It was going to happen if they didn't lay down the weapons at 9 o'clock. This is the council, or the police says this. While the police are busy giving their false verdict, the police start commandos. And all of this must be laid, and we laid ultimately before the National Commission. Could I ask you, members of the board, to delete paragraphs 85, 86? I've looked at them again, they don't take the case any further. We don't rely upon that. I'm not going to
delete 85
and 86.
and 86.
They're not wrong, but they don't advance the case. And then those are essentially, or not essentially, those are our submissions on the first round.
Yeah.
We can then turn, Judge, members of the board, to the second round, which we begin at page 80 of our submissions.
Paragraph 88, so you still want that in? 88, 89?
Yes, it's just 85 and 86 that we've got.
Yeah.
So I didn't get the page numbers.
Paragraphs 85 and 86, we don't go off on any longer.
Yeah.
We then go to paragraph 93, which begins our discussion of the second term of reference at page 80 of our submissions.
Yeah.
And that term of reference originally read, as you will recall, Judge, whether the decision taken to implement a tactical option ought reasonably to have foreseen the tragic and catastrophic consequences which ensued. And given the linguistic difficulties apparent from that formulation and the lack of clarity, it was then requested, you'll recall at the meeting on 15 August, it was decided to request the President to amend the term of reference to read as it does at present, where the decision is imputed to the National Commissioner, the SOT.
And that was granted.
That was granted by the President, and that's why
It was published in the Government Gazette,
that is correct, Judge. We submit that that change is in line with both the facts and the legal position, and we elaborate upon that submission in 95 of the sub-paragraphs. Clearly, the decision was taken at the meeting that the SABC, which included the National Commission, not must have, but did include the National Commission, accepted this position as apparent from what was said by Counsel for the SABC, as set out in paragraph 41 above, which I just referred to. The National Commission, in evidence upon a recall, accepted this to be the case. This emerges from the following exchange. The chairperson, I see now, what the minutes talk about a proposal which the Provincial Commission in North West made. What was the proposal? Chair, the issue I raised is that she indicated to us that their plan was to disarm the protesters. Did she say when this was to be executed? Yes. We were planning to do that on the 16th. So she knew, endorsed, part of the decision. Can't be proved with. Given that everything that followed thereafter was as a result of that fateful decision, and the General PF was both the National Commission and the ranking officer at that meeting, it is submitted that she must take responsibility, ultimately, for the decision taken on 15 August, at the extraordinary session. In making that submission, we rely upon the provisions of the Act and the Constitution that we set up there under. And I'm not going to refer to all of them, but just perhaps to remind the members of the board as to what Section 272 says. It says that the National Commissioner of the Constitution must exercise control over and manage the police service in accordance with the National Policing Policy, etc. So she is the ultimate, has the ultimate control. And it doesn't assist the members of the board to argue, as she does in her submissions, that, well, I'm not responsible for operational decisions. Of course she isn't. She isn't responsible for decisions as to whether to carry out an arrest. She isn't responsible for decisions as to how to react. For instance, was she at the scene had she been at the scene on the 16th of August when those strikers charged the police officers with dangerous weapons? She did not have the authority or power to say either shoot or don't shoot. That is the sort of operational decisions she cannot execute. She must defer to her police commanders. But that differs totally, Judge, members of the board, from this scenario. This scenario, again, we say, was the most significant police operation in this country, possibly ever, but certainly since 1994. The possibilities of violence and death were so obvious that it's precisely the sort of matter where she should have exercised the control of the police force that the Constitution gives her. The fact that she thinks she had no power to do so is itself demonstrative, most tellingly, of the incapacity and unfitness for office. The fact that she submits to this board inquiry that it's not her responsibility is demonstrative, we say, of the incapacity and unfitness. Because she should have controlled the situation. When General Mbamba called in the afternoon to say, we're now going to have the operation, she should have said, why are you doing it now? I understand from Lieutenant Colonel Scott, you've got to do it in the morning. Why are you doing it now? How many people are there? 3,000. No, you can't do it. It's akin to use an absurd example. Because remember, she asked no questions, and that is covered in the following commission. She asked no questions, and she's taxed on that by Judge Farley. But is it conceivable that if she had asked the question, how are you going to do it? And the answer was, well, we've got our tactical police wing there, we can machine gun them from helicopters. Of course that could not have been lawful or reasonable. And of course she should have then acted to say, no, you can't do that. In the same way, she should have acted here. Once the facts of the matter, in broad terms, were relayed to her, that we're now going to do this operation in the afternoon. And that is a fact. We submit. We take issue, members of the board, with the analysis of the matter by the National Commission's legal representatives. We deal with that in paragraph 96, and it refers to something you've just dealt with me. Well, I think that's actually an anterior point. It comes to the matter you dealt with me, namely the question of intent. But in paragraph 96, we say that in her statement of response, she suggests that if the Board of Inquiry finds, as a matter of fact, that she did not take the decision to implement the tactical option, then this term of reference falls away. This is whether she should have foreseen the catastrophic and tragic events. We say that can't be correct. It's clear that a decision was taken and communicated, and if she was aware of that decision, and yet did not disclose it, as we submit she clearly did not, then she must answer to the second term of reference. So the fact that there was inherent problems with the so-called tactical option, that is a complaint of charge, a term of reference that she must respond to, regardless of whether or not she took the decision herself or merely was aware of it and permitted it to occur. In paragraph 98, we make the point that I've already made about the danger of operation at that time. In paragraph 99, we refer to various passages in the evidence by the top police commanders that the possibility of blood being shed was well known to all of them. If this operation was done wrongly, they refer in terms to spilling of blood. And then the intelligence brief that was in paragraph 99.4 presented to the JOCM at 6 o'clock on 16 August indicated that the strikers were in possession of spears, assegais, and pungas, that they would decline to surrender these to the police, that they would not leave the Kopi, and were prepared to fight if the demands were not met, which includes resisting the police. Now, that was one of the questions that I was going to ask the National Commissioner, whether she was aware of that briefing. Had she testified? Because it's highly relevant to acknowledge and permitting the operation to proceed. If she knew of that intelligence briefing, she was grossly negligent. If she didn't know about it, then she must explain why she didn't know about it. Because how can the National Commissioner not know that this is what the police intelligence says? And then finally, with regard to the knowledge and the foreseeability of severe casualties and fatalities, we refer to the undisputed evidence about the request for 4 mortuary vehicles, which I've already alluded to. In paragraph 100, we say, we do not contend the National Commissioner was or should have been privy, this is a point I've made already, to operational detail at the level of the intelligence information and the request for dispatch of mortuary vehicles. But it is our contention that a prudent and reasonable National Commissioner would have acquainted herself with sufficient knowledge and details of the intended operational plan to disarm the strikers in order to satisfy herself that sale was being conducted in a manner consonant with the obligations of the SABC, for which she was ultimately responsible. In the rest of paragraph 100, we refer to matters that I've dealt with already, the briefing and so forth. In paragraph 101, we make the point about the nature of the police deployed, the police assets deployed to Marikana, the knowledge that she must have had about the potential for violence if the police and the strikers met.
You say it is Mawela who deployed the TRP, the STF, and the NIU.
General Mawela, whether I won't go. We've consulted the General Mawela, and we understand that he is the officer ultimately responsible. Whether he actually orders every deployment, I can't say. But the control of those units resorts under him, as is my understanding of the hierarchy in the structure. And you asked that question, General, Judge, apropos any particular paragraph or just in general?
No, I just, paragraph 101, we refer to those units.
Oh, yes.
In paragraph 101.
That's correct. That's General Mawela.
That's where you refer to.
Yes, that's correct. In paragraph 102, we refer to the fact that in her evidence, again upon being recalled, she testifies that even after being informed about the intention by General Bomber to proceed with this arming operation, she asked no questions and for no details about how this was to be carried out. We make the point in 103, if as she testified, and in fact, her testimony, and you see this at page 288, I now recall she in fact did testify that she was unaware of the need to have this operation at daybreak. And we say that is the truth. And again, she would have been asked many questions of us about that. Then she was grossly negligent and incompetent. If she didn't know the most basic point of the entire plan, which is must happen at daybreak. And then the evidence elicited the following exchange with the following commission. The chairperson I see, and I just want to make one thing clear. I think it is implicit in what you're saying. I just want to get one thing clear. I think it's implicit in what you've said already. I just want to make sure I don't misunderstand you. Are you seriously suggesting that the meeting endorsed the proposal without knowing what the details of the operation were? That is not my response to you, Chair. What is your response? My response to you is that we were briefed about the situation, we were advised about the action that was going to take place. There were engagements, but I cannot recall in detail what the response and the inputs were, and we also discussed resourcing. But what I want to know from you, I'm not interested in details, but did anybody ask for some kind of assurance that the risk of bloodshed had been adequately considered and that measures were in place to ensure that if there was bloodshed, it would be kept to the minimum? Chairperson, that detail, as I say, I'm not able to say yes or no to. Now, this is a question as to whether there's been consideration of the features of operation in order to minimize bloodshed. One would have thought this is the most fundamental question. She says, I'm not able to say yes or no, because I'll be doing some injustice, because you want me to say, who was saying that? I don't know. And then this is very important. That discussion must have taken place not did take place, must have taken place, because we were discussing this disarming and whatever. I'm not able to give those pedantic details, checklist, to which Judge Farland responds, as we all know that he's wanted to do. Well, I want to make 2 points to you. One is not a pedantic detail. The second point is you wouldn't be doing justice to the person who raised the problem. You'd be doing the opposite. But you can't help me on that. So what flows from that exchange is she can't testify that this was discussed. The question as to how to minimize bloodshed, what the details of the operation were, all she can say is it must have been discussed. But the reference to it must have been discussed is demonstrative of her realizing the importance of this. So if she was genuinely unaware, if no one asked any questions about how this was to be done, we've made this submission, that makes her grossly incompetent and unfit. But she says, well, it must have been discussed. I can't tell you what the details were. I can't tell you who discussed it. I can't tell you how they were to be minimized. It's just unsatisfactory for the National Commission in evidence before the following Commission to testify like this. But that is why, for that reason too, because they couldn't get to the bottom of it, this inquiry was set up specifically to investigate the conduct of the National Commission. Because the following Commission was very broad-ranging, as you will see from the report, very broad-ranging Commission. This was a specific inquiry focusing on the conduct of the National Commission, precisely to get to the bottom of this sort of thing. How could she not have known about this? And she chose not to testify. And we say that says it all. In fact, sorry, in paragraph 113 and 114 I deal with the exchange that you and I had, Judge, about intent. We say that in a statement of response to the evidence leader statement of case, the National Commission makes the curious assertion that there is no evidence whatsoever that was placed before the following Commission which demonstrates on a balance of probabilities that the National Commissioner did in fact foresee the tragic and catastrophic consequences. We say the statement is curious because if there was evidence that she did actually foresee the tragic and catastrophic consequences, it could well be argued that she was guilty of the common law offences of murder and assault with the intention of committing grievous bodily harm on the basis of the principle of delicate and childless. However, the term...
Can I interrupt you there?
Yes, Judge.
On paragraph 113.
Yes.
If that assertion is correct, that there was no evidence whatsoever that she did in fact foresee, isn't the purpose of this inquiry to engage in that issue, to find out did she or did she not foresee?
In part, yes, Judge. That's so. As part of a general understanding, so as part of a general investigation into what happened. But the term of reference itself isn't predicated on knowledge. It says ought reasonably to have foreseen. So the term of reference itself says not that she did know, because then I said that she would be guilty of criminal offences. The term of reference is should she have foreseen? Would a reasonable, competent National Commissioner have foreseen? And the answer to that is unequivocally yes. So we say on the second term of reference too, Judge, as a board, you should find the National Commissioner.
We don't have to find that she actually foresaw it. It's a question of should she have foreseen it.
And we say
that's the finding that we are called upon to make.
That is the finding that you're called upon to make. Yes, should she have foreseen? And we say you will find that she should have foreseen. There may also be suggestions that she did foresee, but that's not our case. Then, Judge, the third term of reference, where the remarks of the National Commissioner of the SABC parade on 17 August would have been understood to be an unqualified endorsement of police action, thereby having the consequence of undermining, frustrating, otherwise impeding the work of the Commission. It's now common cause that reference in the term of reference is incorrect. It wasn't into a parade. There were two parades, one on the 17th and one on the 20th, and these remarks pertain to the 20th. the relevance of that, Judge, is that the following commission had been proclaimed, or at least announced by the President prior to the 20th. So at the time the remarks were made, she knew that there was going to be a commission of inquiry by a judge. And nonetheless, she makes the remarks that we then refer to in para 116. I come before you to actually say, trying as may be, mourning as we are, let us take note of the fact that whatever happened, we represent the best of responsible policing. You did what you did because you're being responsible, you're making sure that you continue to lead. We submitted you to deliver, we said. Your oath of ensuring that South Africans are safe and that you are equally a citizen of this country and safety starts with you. We submit that those words can only be read in context and in its entirety of the whole speech as an unqualified endorsement of the police action. It says, in terms, what you did represents the best of responsible policing. Now, that could never be correct, factually, for obvious reasons, unless it's assumed that the police, the proper method of policing is to shoot people down. And to do so, or rather to launch operations where there's a very good likelihood of that happening. That represents the best of responsible policing, which obviously it doesn't. In paragraph 119, we say that in the statement of response, in paragraph 128, the National Commissioner says, in response to a proposition by us, that she should have made balanced comments at that parade, that what constitutes balanced comments is dependent upon a subjective test and differs from person to person. That is plainly not so. What constitutes balanced comments, Judge and members of the board, is subject to an objective test. It's balanced and it's objectively balanced. And we submit the subjective views of people as to what is balanced comments is not something that will be claimed as board. In paragraph 120, we make the point that I've already made, that the following commission was announced on 17 August 2012, and thus she knew by then that it was going to be a commission. And she should have known that members of the police, both the president of the parade and also not president, would take the lead from her. And given that she now, on the 20th, proclaimed that what happened constituted the best of responsible policing, obviously, there's every likelihood that other police who look up to her are going to follow that lead and regard this operation as it being properly planned and carried out. And we know from all the evidence led at the following commission how badly planned and conceived this operation was, to the extent of a briefing taking place off Lieutenant Colonel Scott's laptop in the back of the meter, without any plans or maps being given to the police commanders. We say the remarks in paragraph 121 were particularly inapposite because she did not have all the facts at her disposal. And subsequently became apparent at the commission what happened was anything but the best of responsible policing. The operation was planned in an amateurish manner because it was decided to proceed so late in the day. Members were not properly advised of their roles and functions, and command and control broke down, especially at scene 2. You will know that the following report describes scene 2 as chaotic, and in fact evidence is that it was chaotic. Lieutenant Colonel Vermark in the helicopter couldn't hear what was being said. People were shouting, there were screams, there was shooting, no one was in charge.
He was in the helicopter.
Vermark was in the helicopter, yes. Captain Kidd was on the scene, there was Brigadier Naidu, people were running around. It was a total mess, scene 2 in particular. And that's quite apart from the allegations that people were deliberately shot when they shouldn't have been at scene 2, which will be dealt with, I think, by my colleagues. And then we say that the claim to the best of policing rings in para 122, particularly hollow in regard to Standing Order 262, which the National Commission testified to at the commencement of the first round of evidence. She was aware of 262. She says as much. 262 under execution, para 11.3a says the following. The purpose of offensive actions are to de-escalate conflict with the minimum force to accomplish the goal, and therefore the success of the actions will be measured by the results of the operation in terms of cost, damage to property, injuries to people, and loss of life. Now that is not extraordinary, but it would say that a successful operation depends on these factors, including injuries and loss to life. And we say by this standard, the operation was a total disaster. How could it ever be the best of responsible policing? It was a disaster, for which the captain of the ship, the head of the police, must take responsibility. In paragraph 123, we refer to a passage where she claims, in the same speech, that the police had just put facts before the media, and the media were left to make their deductions, and the police had merely made factual evidence. And we say in paragraph 124, these statements are breathtakingly inaccurate, if not false. The remarks were made 4 days after the shooting. It could have been expected that by then the National Commissioner would have been properly informed about the factual position, which clearly she either was not or she was being deliberately dishonest in these statements. And in paragraph 126, we make the point that in the statement she maintains the position that what the police had thus far said in the media was accurate. If she did not know by then that what she had said in the media statement of 17 August 2012, as dealt with in the next section, was seriously inaccurate, she was grossly negligent. Of course, if she did know by then that the statement of 17 August, which I'm going to deal with now, was incorrect in a number of respects and misleading, if she knew it, then she was being dishonest with the police that she was addressing by saying that we've been factually, we've just put facts out to the media. So that's the point that we make there. Then on page 98, members of the board, we deal with the fourth ground. And that is the amendment of the two, or the amendment of the second statement, and the question whether it was deliberately amended to conceal the fact that there were 2 shooting incidents, 1 and 2, resulting in misleading the public that all the deaths had occurred at scene 1, which arose out of members of SABC having to defend themselves from an advancing mass. Now, those statements, the 2 statements, are annexures inter alia to Captain Riah's first statement, and it's part of Exhibit B. And it might be useful for the members of the board to look at them.
Yes, we have Exhibit B here.
Yes, they are dealt with on pages 17 to 18 and 19 to 21, respectively. And we now know, because we've heard, while we've read the following evidence, and we've also had the benefit of hearing Brigadier Mosheku, as you will recall. To just run through the facts relating to that, which appear now to be common cause. On the evening of the 16th, we know Captain Riah goes back to the jock, or the jockam, about 8 o'clock that evening. He then meets with the National Commissioner and other police officials. And at some point, the National Commissioner is asked to provide a report to the President, who's in Mozambique, and wants to know what's happened, so that he can make a decision as to whether to return or not. That leads to the triple F4 document, which is prepared now, and which you find at page 17 of Exhibit B. That document is dealt with in paragraph 131 of our heads, where well, actually, that's not dealt with in 131, but the facts, as I say, are not in dispute. The evidence for the National Commissioner when she testifies about this is that the Triple F4 document, as well as the Triple F5 document, were both prepared on the evening of the 16th of August into the early morning of the 17th of August by a team which included Riah and Brigadier Mashefo. That was the evidence at the following commission. Now, we know now that that's not correct, because both Riah and Mashefo denied that they had anything to do with Triple F4. In fact, Mashefo has testified, and he was never contradicted on this in cross-examination by Mr. Mukari, that he was not at Marikana on the evening of the 16th. You remember that evidence. He only arrived on the morning of the 17th. So obviously he could not have sat together with the National Commissioner and Captain Riah and prepared Triple F4. And that, as I said, appears to be common cause. And when she's recalled, the National Commission is asked by Judge Follen, and this to deal with in paragraph 131, about the changes between the two documents. And again, in order to save time, I'm not going to take you all the way through this because we set it out in detail. But the long and short of it, Judge and members of the board, is that there are crucial differences between the two statements, and there are apparent differences. And the most important difference we submit is not only the fact that in the media statement which is issued and which she reads out at the press conference on the 17th of August, not only are the two different fatality figures that you find in Triple F4 removed and now collapsed into one figure, which was an updated figure, but there are crucial sentences which are added in relation to the second incident. So the one aspect is that the numbers are removed from the two separate numbers are put into one. And the second one is that words are deliberately added to the Triple F5 document. And can I just read to you the resultant
Comparison.
well, not comparison, the resultant version that's given in the second document, which you find on page 20, the Triple F5 document. And this reads as follows. When the police started deploying the barbed wire fencing, the group of protesters armed with dangerous weapons and firearms hastily flanked vehicles deploying the wire. There were met with members from the police who tried to riposte the advance with water cannon, tear gas, as well as stun grenades. The attempt was unsuccessful, and the police members had to employ force to protect themselves from the charging group. Now, of course, in the first document, that is virtually verbatim what the first document says. But the first document then has the additional line, this resulted in the death of 16 protesters with 13 wounded at that scene. It has the words at that scene, which you find on page 18. And then, in the new version, we have the following paragraph. The dispersion action had commenced at this time. This is after that sentence is now taken out of the numbers who died. The dispersion action had commenced at this time, and the armed protesters were driven from their stronghold to a high bushy ground in the close vicinity. Now that can only be and is the second incident. It's the Poppy. The police members encircled the area and attempted to force the protesters out by means of water cannon, rubber bullets, and stun grenades. Now, these are the crucial words that are added, that are not to be found in the first version. The militant group stormed toward the police, firing shots and wielding dangerous weapons. Police retreated systematically and were forced to utilize maximum force to defend themselves. The total death toll of the protesters currently stands at 34, with more than 78 injured. Now, that reading to anyone, members of the board, well, doesn't suggest it. It says, firstly, that there was a militant group, and this will be talking about the second scene, that stormed toward the police, firing shots and wielding dangerous weapons. Police retreated systematically and were forced to utilize maximum force to defend themselves. We know from all the evidence that was led at the Farm Commission that is not what happened. did not happen at the second scene. There was no group that stormed the police. The police did not retreat systematically or otherwise. And they did not use force to defend themselves in the sense of what happened at scene 1, where there was a militant group charging them and where they were required to use force, which ties in with the video footage which all of us saw at the time. This account, the second account, not only collapses the fatality figures, but it would neatly tie into a police version that says that the police were compelled to defend themselves when attacked by a militant group. Look at the TV, look what they did. That's why they died. We had to shoot them to defend ourselves. That is what this account in the media statement conveys to any reasonable person. Now we know, because Brigadier Mashir could tell us this in his evidence, and it's the reason he was called, those changes that I've just read to you were deliberately inserted at the instance of the National Commissioner herself. Not by any underling, but by her herself. He said, I did it on my laptop, she stood behind me. Now, given that evidence, there were only two possibilities open to her. She had to accept that that evidence was correct, or she had to deny it. And we all know, members of the court, that the way you deny things in a court or adversarial process is you put it to the witness that that is not correct. My client or my witness will come and say X. And it's the oldest rule that we all learn at university. You may not ask the tribunal or the court to disbelieve a witness when you haven't put the version that you say demonstrates that the witness is being dishonest to the witness. That wasn't done here. It was glaringly obvious in a 2.5-hour cross-examination of Mr. Mashir before you. The one question that was never put, the one proposition that was never made is, it's denied, it's not so. It wasn't her. Someone else. You say, you lie. That wasn't put. That means that it must be accepted and will be accepted going forward that she was the author of these changes. Now, if she was the author of these changes, she intended to mislead the media and the public. Now, I can think, I've thought about this, I can't think of any other reason other than that she intended to mislead the media and the public by making these very deliberate changes. These are not changes that could have been made by mistake or made inadvertently or as an oversight. These are deliberate insertions and deletions. I can think of no other reason other than deliberate intent to mislead. But if there conceivably could have been another reason, then she would have had to come and tell this board what that reason was. But she hasn't done so. And that is entirely destructive in my submission of her credibility and integrity and a fitness for office. That she's the author of deliberate fabrications, which are then presented to the public as being the correct account of what happened. That is what we want to say about that term of reference. Could I then go on to the final aspect of the report, and that begins at page 109 of our submissions. And I'm not going to take too much time because I've touched on this already. We take issue with the National Commission's understanding of the constitutional and statutory role, and we've dealt with that. So I'm not going to return to that and delay you with that. If we can then go through to we then go to 164 of our submissions, where we say that so the question of was the National Commission's testimony in keeping with the office, we interpret this to refer not only to the manner in which she testified, but also to the substance of the testimony. That is, whether such evidence demonstrated a proper understanding and appreciation of the role as National Commissioner. We've already referred in our submissions to the ruling that you made at the outset of this inquiry as to whether we could refer to matters that occurred after the following commission, including representations. We were permitted to do so. And we then in 166 say that we are going to deal with the following examples or instances of the evidence that we say renders unfit for office. I could get, yes. If I could go through them then at page 121. The misunderstanding, misstatement of the Constitution and statutory functions and responsibilities. I've already alluded to this, but to just make the point, in paragraph 170, in her representations to the President, she says, "It is my humble submission that I was never aware that the plans that would be implemented in the morning or afternoon of 16." So she says in the morning or afternoon of 16 August. That itself demonstrates the problem that I've already referred to. It seems to make no difference whether this operation was to be conducted in the morning or in the afternoon. They were totally different. Totally different scenarios, different risks, different likely outcomes, different potential for total disaster. It made a fundamental difference whether it was done in the morning or afternoon. She says, "I did not give my approval to such plans and I do not have the authority to do so. There was no reasonable evidence put before the Commission to draw an inference that I'm responsible for granting such approval." So what she's telling this Board of Inquiry is that if she'd been told that our plan tomorrow is to shoot as many people as we can, if they don't move when we told them to move, we're going to shoot them. If that's the plan, she says, well, it's not my responsibility. I don't have the approval to grant or say you can't do it. That's extraordinary to come from the National Commission. We've dealt on page 123 in paragraph 172 with the failure to show leadership, but not asking the details of the plan that's been dealt with. The next one is the complicity in putting false misleading evidence before the Commission, especially Exhibit L. We've dealt with this. We say that she made public statements, that's on page 124, without having the relevant facts and or reasonable basis for making such statements. And those would involve the media statement of 17 August, so that stands on its own as a reason arising from a testimony, we say, which renders unfit for office. Also, the remarks on 20 August at the parade. Now, the next one, Judge, is the failure to cooperate with the following Commission, despite undertaking to do so. And we refer to two incidents. Now, I need to tell you that with regard to the so-called Irova incident, we made the point that there was a disclosure, and we rely upon it in what follows at paras 177 to 182. Our letter friends have taken issue, or the Commission have taken issue with us for raising that. And in the heads of para 180, they suggested, they in fact say, in para 179 of their heads, that there was a retraction of this email that was inadvertently sent out by the attorney, and a claim to privilege in the retraction said this was sent out of mistake and we claim privilege. And then it's suggested in para 180 of the heads that we as the evidence leaders were aware of that retraction and didn't bring it to your attention. Now, I've conveyed to Mr. Makari the fact that myself and my two evidence leaders with me, advocates Masuka and Kazavitsky, were entirely unaware, as a matter of fact, of the retraction. I've conveyed that to him, and he has kindly accepted that information from me, as I understand.
Yes, indeed. We did speak about that part, and that we are not pursuing what you were saying that you are aware, because they've given us an explanation, and that they're also no longer relying on this term of reference, on this incident, and so it should simply accordingly be expunged from your records. Thank you. And that also that nobody should refer to it.
I'm indebted to my learned friend for that. We were of the view legally that...
sorry, my junior was saying that I should explain the line, said that nobody should refer to it, including the press. That's what I'm saying. Thank you.
The long and short of the judge is that Whatever the position might be, we looked at the legal position in this country, and there was authority that a communication that is, in respect of which you can claim privilege, but which has been mistakenly disclosed, loses the privilege. But we satisfy that is there's authority in England, which is to the contrary effect. We're happy to leave this point. We don't pursue the point. So you can draw a line, Judge, members of the board, through barrows 177 to 182. We no longer rely on it. The Mark incident, on page 128, we've made our submissions, and we say that called for an explanation, and we stand by those submissions. And then we get to the point about inappropriate political considerations. And this, you'll recall, you debated with my little friend Mr. Porker yesterday, and you seemed to express a preliminary view, Judge, that this fell outside the ambit of your terms of reference. We are of the respectful view that it does fall within your terms of reference, and very, very squarely so, because the term of reference is whether she with the overall testimony, I just want to see whether her overall testimony is in keeping with the office that she holds. Overall testimony whether the overall testimony of the National Commissioner at the Commission, was in keeping with the office that she holds and the discharge of the duties commensurate therewith. Now, we've said that we don't believe and submit that refers only, if at all, to the way in which she testified. In other words, whether she was rude or whether she was dismissive of the board. That can't be the purpose of this term of reference. This term of reference requires an examination of what she said at the Parliament Commission and whether what that reveals about her indicates that she's fit for office, or the contrary. And that's how we interpret it. And on that interpretation, we submit that whether she took into account, as revealed in the evidence, improper political considerations, that is highly relevant to her duties as a National Commissioner. And I see you furrowed your brow, Judge. Well, could you indicate, if you indicate to me what the difficulty is, I'll attempt to address it.
Well, it's simple reading.
Yes.
Of, let's call it number 5 in terms of reference.
Yes.
You quoted on page 109.
Well, no, I couldn't follow
It simply says whether the overall testimony of the National Commission at the Commission was in keeping with the office which she holds and the discharge of her duties commensurate therewith. Now, I read it as the overall testimony. And so you have to look at her testimony to decide whether her testimony was in fact not commensurate with her duties. I can understand that what would fall within the parameter of this particular terms of reference would be the fact that she withheld important information in her testimony. That clouds her testimony. But the question of whether there was political influence in her making a decision, I see as totally different from what we need to decide as to what the nature of her overall testimony was. Political influence in making a decision could very easily have been included in this particular terms of reference, either as an additional term of reference or as an explanation or of the fifth term of reference. But the fact of the matter is, the question of this so-called political influence allegations were dealt with and were disclosed at the Farm Commission, and the Farm Commission dealt with that and said, well, they're of the view that there's nothing in it. So I still maintain that if the President wanted us to look at that, he could very easily have said so. To now look at that requires us to extend the terms of our reference, which I don't think we're entitled to do.
Sorry, John. So I'll turn away from you for 1 moment. I was trying to get some.
Yes.
Judge, with great respect, I fully agree with you that it pertains to a testimony, and that's the only position. So we do not, and I just want to make this very clear, and we differ here from our friends to my left, I think. We don't suggest that there was political interference, and we don't even suggest that it was taken into account. We simply don't know because she elected not to testify. But what we do know is how she dealt with this issue in her evidence, and that's the only aspect I'm relying on. So I'm squarely putting it within the confines of your terms of reference. And we try to explain how we do that. We say, Judge, having referred to the exchange with Mr. McWenna, which you find at pages 131 and 133, and we've all gone through it, we don't need to go through it again.
Yeah.
On its face, and I put it no higher than that because I don't need to, on its face, the conversation, remember this is a conversation not with the National Commission. It's a report, as it were, by Lieutenant General Bombo to Mr. McWenna about what the National Commission is supposed to have said in another conversation between her and Lieutenant General Bombo.
So that's actually already hearsay evidence in the second degree.
It's double hearsay. But that's not the end of the story, Judge, because the double hearsay is then put to the Provincial Commissioner and the National Commissioner, and in their own evidence at the Farm Commission.
Yeah.
That's what I'm doing. So in para 194, we say that both the Provincial Commissioner and the National Commissioner admitted that the remarks alluded to by the Provincial Commissioner...
Hold on, where are you reading from?
Para 194, Judge.
Sorry.
It was not put in dispute by them in the evidence that the remarks were made. They both, however, tried to explain away the remarks as being innocent. Now, in her representations to the President, and this is quite important, how she deals with it, Judge, and remember, we've been allowed by you to refer to her representations. At those in those representations, at page 22, she deals with this question. She deals with this in the context of alleged bias against her on the part of the Farm Commission, and she says the following at page 22 of those representations. My observation about the Commission and how it was conducted is that it was biased and overly hostile to me and some of my team members. I mentioned just one example. The conversation between Mbombo and McWenna of London, which I was not party to, in answering the Commission questions when I testified, now this is the important words, Judge, when I testified that I did not remember speaking to Mbombo about Malema. So her evidence is that I did not remember speaking to Mbombo about Malema. It's not that I did not speak to Mbombo about Malema, it's I don't recall speaking to Mbombo about Malema. The Commission agrees with the evidence leaders that even if I did not remember the conversation, I should still have disputed Mbombo's testimony. With respect, I do not know how one disputes information that one does not recall. That's what we rely upon. And we say that answer, so she doesn't dispute. She says, it's of the nature of, I wasn't there, I can't dispute it. But I don't remember that conversation with Mbombo about Malema. Now the question we have in this inquiry, Judge, into whether her testimony at the Farm Commission renders her unfit for office or not, is how can that be correct? You're the National Commissioner. This is a long, detailed conversation about the supposed malign influence of Mr. Cyril Ramaphosa, who was not then the Deputy President of the country. But it goes into the intricacies of Malema, his previous involvement at Amplats or Implats, the fact that Ramaphosa was the chair of the disciplinary inquiry, which ejected Malema from the ANC. It's highly political. on the eve of this operation. They're having this conversation. And her answer is, I don't remember it.
Can I just interrupt you?
Yes, Judge.
I don't dispute in our debate that it is political.
No, I know that.
Yeah, it is political. My concern is, if that is political influence, where do we fit it into the terms of reference? That's my big concern.
You fit it into the term of reference that in respect of a clearly improper conversation.
That may be so.
No, but where do you fit it in? You fit it in like this, Judge. In the light of a clearly improper conversation,
Yeah.
which is testified to by Lieutenant General Mbombo as having happened, your response to that under oath is, I don't remember the conversation. That is how you fit it in, because that is an insufficient answer. The National Commissioner could be expected to say, no, it didn't happen. Or, yes, it happened, but we were just joking. Or we were just chewing the fat, or whatever. She should have said that at the Farnham Commission, and she should certainly have said it in this inquiry so that I could have cross-examined her about it. She chose not to twice to deal with it. Her answer in the Farnham Commission is, I don't remember, and there's no answer here. And that's how it fits in, Judge.
Your point is well taken, that she did not answer those allegations of political influence. But the problem is, the premise is, was she obliged to do it? If it did not fall within the terms of reference of this inquiry, then she wasn't obliged to answer it.
But the Farnham report said she should be investigated. The President appoints this board to investigate, and one of the terms of reference is, did the evidence of the Farnham Commission demonstrate her fitness for office or otherwise? Right? That's the term of reference. Now, among the evidential material before the Farnham Commission is the fact that there was this improper conversation. And her answer to it, it's part of a general submission we make that she was dishonest, withheld information, failed to be frank with the Farnham Commission, and that those findings are amply justified by the record in the Farnham Commission. Among the facts that we rely upon for that assertion is this one, that in responding to a very serious allegation, her answer is, I don't remember. That is insufficient. It demonstrates a failure to take the Farnham Commission, and by extension this board, into her confidence. And we say it's again demonstrative of unfitness for office. That's as far as we take it. We don't say that there was or wasn't political interference. And the fact that the Farnham Commission finds that there wasn't is immaterial. She should have responded. It's immaterial that the Farnham Commission finds that, Judge. She should have responded in terms and frankly to Judge Farnham by either saying, yes, it happened, and this is my explanation, or no, it did not happen. Lieutenant General Mbombo is either lying or is mistaken.
I accept that if the terms of reference required this board to make a finding in regard to that political improper discussion. And that's where your premise,
Judge,
in my view, falls.
That's not a good enough answer.
Why not?
Because if you tell me, Judge, that I punched you, if someone says I punched you, and what do I say about that? I'd say, of course it didn't happen. I would never punch you. So accordingly, it's not something I can be two-minded about. Did it happen? Didn't it happen? I can't remember. There are some things you do remember.
No,
if you discussed...
This is not a punching, it's not a question of conduct. It's a question of a conversation which happened quite some time ago. And many people can't remember exactly what was said in any particular conversation.
Judge, I don't take it further.
Okay, fine.
We've made our submissions. And the last aspect, Judge, but the rest of it speaks for itself. I'm not going to address the remaining sections. But our conclusion at paragraph 210 is we say that for all the above reasons, it is submitted that it's been established that the National Commission has acted in breach of the Constitution and the law, including the Code of Conduct, and accordingly that she is guilty of misconduct, is unfit for office, and is unable to carry out her duties in accordance with law. And in the circumstances, we submit that this Board of Inquiry should recommend that in terms of Section 86B5, read with Section 9.1 of the Police Act, General Phiyega be removed from office as the National Commissioner of the South African Police Service.
On this question, you don't contend for any other, shall I say, relief under what the section allows this board to recommend, like, for instance, a reduction in salary and that kind of stuff. You don't rely on that, do you?
No, Judge. If you're with us on our submissions, then we submit that the conduct of the National Commissioner is so egregious and serious and departs so far from the standards of what we can expect from someone in that very high position that the only proper penalty would be removal from office.
Yeah. Mr.
Those are our submissions. Thank you, Judge.
May I congratulate you? You said you'd be finished at 12 o'clock. It is now 5 seconds past 12 o'clock. Well done.
I apologise for those 5 seconds, Judge.
You'll have to make an excuse for that 5 seconds.
I do.
Yes. Yeah. Would it be in order if we take a comfort break for only 10 minutes? So if you go wherever you need to go, be sure to be back in your places in 10 minutes' time. That's 10 past 12, not 5 seconds past 10 past 12. Thank you.
See, with the question that you asked, the final question you asked, I think the problem is with the fabrication. So, once we presented mitigating